Is that this year has been full of the highest highs and the lowest lows of my life, and I see so many women around afraid to speak right now, afraid to share their experiences, and fear is by design. It's what keeps us silent. But I also acknowledge that many people don't have the opportunity to speak, so I do feel fortunate that I've been able to, and it's the women who have had the ability to use their voice that's kept me strong and helped me in my belief and my fight for the world to be safer for women and girls. It's a pretty simple thing.
Hi friends, it's Katie from Without a Crystal Ball. Welcome back to my channel. Blake Lively's new movie, Another Simple Favor, came out yesterday on Amazon Prime, straight to streaming. And there's been a lot of headlines. She was on Seth Meyers last night, and not without consequence, she made a statement about her legal lawsuit with Justin Baldoni. And when I say not without consequence, is that anything that she says publicly will be used against her in court. And one of the allegations against her is that she is using a smear campaign against Baldoni to tarnish his image and destroy him and to basically get the rights of a movie. It Starts With Us. I don't really know what her end goal is at this point. I just found it very odd that she used her children to parlay the beginning of this video. She basically said, I'm leaning on my kids right now. They're my only source, blah, blah, blah. It's been a very rough year. And then Seth was like, oh, since you said that, would you like to say something? It was very rehearsed, very rehearsed. And then she gave that very rehearsed statement to Seth, claiming to be a spokesperson for all women, but she's not. And Blake Lively's narcissism was on full display in the Seth Meyers interview. And I'm of the belief that people that are like Ryan and Blake, they cannot help themselves. It's no different than Ryan Reynolds showing up at Green Day's Hollywood Walk of Fame, getting their star ceremony, making an 8-minute speech that was basically all about him. And he said nearly next to nothing about Green Day. And he recently only met them a year ago or 2 years ago when he was making Deadpool and Wolverine. It was just a really weird ad that he would be there. And it kind of felt like maybe he's the reason they got the star, because I don't know why he was there, but he made their moment about him. And Blake made that moment about her victimness and martyrdom, Covert narcissists love to be the martyr. They love to play the victim, and they love to manipulate people through sympathy. So here's the thing. Blake Lively and Ryan Reynolds are fooling the public right now. And Blake Lively's new movie is terrible. Absolutely terrible. I sat through it because I have Amazon Prime, and it's free for Amazon Prime users. And because it was free, I watched it, and it was terrible. The plot was all over the place. It didn't make any sense. I couldn't figure out why Stephanie would even be in Capri. And Blake, who claims that she's the co-star, she's barely in the movie. I was shocked how little she was in the movie. But in the movie, she threatens to sue Anna into oblivion for using her name and likeness. She uses threats about lawsuits a lot in this film. And she talks about wanting to destroy people. And I don't know when these lines were added, if it was in post-production that Paul added the into oblivion part, but I just feel like if you're going through a lawsuit and you are literally on the receiving end of a $400 million lawsuit, you should probably not say things like that. I don't know why they do things like this. I don't. Either way, the movie's terrible, but you know what's the worst part about this movie? Blake plays two characters. She plays Emily and Charity, and they're sisters. They're triplet sisters. So they're identical triplets, and their other sister she killed in the last movie. So Emily and Charity are in this movie, and the other one is gone. And Charity is apparently didn't die at birth and was raised by some lady who's her Aunt Linda. And Charity is mentally ill, disabled, and clearly is in love with Blake. And at the end of the movie, Charity fondles Blake while she's been drugged. And it's gross. So it's Blake doing this to Blake, even though it's like a body double. It's just disgusting. And it's like nobody in the media is talking about that scene. No one. No one. They're talking about this movie like it's just this great thing. And I'm like, this is what we're watching in 2025. Incest? Gross. Gross, Paul Feig. Gross. And this book, this sequel is not from a book. This was a script written by Paul. Gross. And she claimed that Justin was trying to add obscene stuff to the film. I did notice in this film that Blake didn't really have any intimate scenes, and that's probably by design. And the only time she was cuddling anyone was herself. And I also noticed that when she was supposed to be getting married to her husband in this film, it was really because she was being the beard for her secretly gay husband. There was a lot of references in here. I just felt like, what are they doing here? Are they mocking that they think Ryan is gay? I don't know. I think that her actual hands are in this script way more than Paul Feig would like to admit. But in the middle of her taunting Baldoni and taunting him through the Seth Meyers, adding to the smear campaign with the Seth Meyers interview, the taunting in the actual movie, these are not the actions of someone that's been sexually harassed. And people that are victims don't behave like this. And this is someone that I believe is very entitled and is using her platform to further decimate and destroy Baldoni. And I don't believe she will stop ever, because to her, she wants to be the advocate. But it's just weird because she had an opportunity to speak up last August for victims of domestic violence, and she didn't use her voice. And now suddenly she wants to be the voice for women when she had an opportunity last August. Why wasn't she a voice then? Why is she a voice now? It's disingenuous, and it's obviously a manipulation to try to flip and project and deflect. And I think what's the most disappointing for me, at least as I've been watching this play out in the media, is I am someone that has been fighting against the lack of transparency by the legacy media for years. One of the reasons I started covering Sister Wives and doing it in a way where I was uncovering the truth about polygamy was because I was so angry with the way the mainstream media covered polygamy. I was angry at how they covered Cody and acted like this was normal, and they acted like it wasn't a cult and there wasn't abuse. I was angry at how the Duggars were given this platform when they were a part of this insidious cult, and they were promoting these very abusive, horrible practices that harm women and children. And I'm just tired of the being gaslit by these Hollywood people that don't have a soul and don't care about what they're promoting. And it's just becoming more and more apparent to me that there's a reason why so many people are not watching or consuming mainstream media. It's because they pander to people that are narcissistic, abusive, and they allow the gaslighting to continue, and they don't push back. I have yet to see anyone in the media push back against these claims, other than maybe Billy Bush, who does some stuff on Extra, but I haven't seen a single journalist push back, not one. And that's what the job is of the press. They are supposed to ask questions. They are not supposed to simply be the PR vehicle for a celebrity to make them more rich. We're supposed to be about holding people accountable. Okay. But moving on, yesterday I spoke to you about what was happening with the case and how Stephanie had filed for a motion to compel. And I said yesterday that I felt like everything that she was doing was so premature, that she honestly shouldn't have been filing this, that she was doing this to get in front of the judge to remind them that she has a motion to dismiss. Some of you in my comments reminded me that she actually sought a stay on discovery. So you thought that this request was disingenuous, because it's like, well, what do you want, Sloane? You want to stay on discovery, or do you want to be compelled? Which is it? Do you want to stay on discovery, or do you want to be compelled? And then we talked about how she brought up the wiretapping stuff. Okay. Well, they responded with a letter to the judge as well. It's pretty succinct here. And I'm going to try to be a good reader, not read too fast. I know some of you don't love that I read, but I do this for those that do. So it says the Sloane parties have notice of the claims against them. And I want to say this before I start sharing this is that a lot of the things I brought up yesterday in my video are actually mentioned. So I either have a good pulse on the legal side of things or they pay attention to me, but I have a sense that I'm just maybe making good assumptions based upon what I'm seeing, based upon my experience of covering cases. So the false premise of the Sloan party's motion is that they purportedly lack notice of the Wayfair party's claims against them. However, the parties amended their complaint alleges that the Sloan parties made statements to third parties, including the New York Times, to the effect that Baldoni is a sexual predator who sexually assaulted Lively, and that Baldoni retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. Pretty clear. The amended complaint alleges that the Sloan parties made further false statements in response to media inquiries concerning Lively's wrongful accumulation of power over the production, how she did so, i.e., the false accusations of sexual misconduct, and the resulting turmoil. So this is really one of the first times we see them say she's using false allegations of sexual misconduct in order to gain power. And specifically, the Sloan party stated to the Daily Mail that reports of a power struggle on set were 1000% untrue. Your info is totally off. You have it all wrong. Your reporters are so wrong. Instead, the Sloan parties seeded false information to cast Baldoni rather than Lively in a false light. The whole cast doesn't like Justin, nothing to do with Blake. They, Wayfair, are panicking as the whole cast hates Baldoni. I don't know a lot about the false light claim, and I don't know about what defamation covers in terms of like if it doesn't have a criminal aspect. If it's seriously just they lied and said something that wasn't true, even if it's not super bad, you know what I mean? I guess I'd have to look into that aspect of defamation. But my understanding is of what their defamation claims are against her is that she intentionally misled the media about what was happening on set to try to deflect it onto Justin and make it seem like he was the problem instead of Blake, doing a game of misdirection. And she was doing it because she wanted to cover for Blake. That's how I'm viewing it. Okay. And whether or not those statements will prove to be defamatory, I don't know. But if she's using it to cast a false light of him, that would make sense because you're trying to like show that he's someone that he's not. And then there's a little point here at the very bottom. It's a footnote, and this is about those wiretapping calls. Okay. The Sloan parties falsely allege that Melissa Nathan serendipitously listened to Mrs. Sloan's phone calls in violation of California's wiretapping statute, California Penal Code 631. Amazingly, 2 sentences later, the Sloan parties acknowledged that they lack knowledge about whether the Daily Mail or Nathan added the other to a private conversation without Miss Sloan's consent. In other words, the Sloan parties have no knowledge that Nathan did anything inappropriate. In any event, and putting aside the recklessness of the allegations, the conduct described by the Sloan parties does not constitute wiretapping under the cited statute. I think they're just trying to put that to bed because they don't bring it up as a claim. The amended complaint also alleges that they made one or more statements to third parties, including to the New York Times, to the effect that Wayfair parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct toward Lively and others, and retaliated against Lively for reporting the alleged misconduct, including by propagating false narratives about Lively for the purpose of damaging her image and reputation. The pleading alleges that the Sloan parties told the New York Times a false and damning story about an insidious PR sabotage operation deployed as revenge for sexual harassment complaints, with the knowledge and intent that the newspaper would publish the false story, and that the Sloan parties propounded a false smear campaign narrative designed to destroy the Wayfair parties. You know, I feel like in that New York Times article, I'm going to look this up. I feel like there was a statement by her team in this article. In the article, Blake Lively issued a statement that said, "I hope that my legal action helps pull back the curtain on these sinister retaliatory tactics to harm people who speak about misconduct and helps protect others who may be targeted. She also denied that she or any of her representatives planted or spread negative information about Mr. Baldoni or Wayfair. It's also interesting that in the article, it says that her filings includes excerpts from thousands of pages of text messages and emails that she obtained through a subpoena, which we now know is from a sham lawsuit, and that these are other documents were reviewed by the New York Times. So another thing I noticed about this New York Times article is that they keep saying that they were relying on the CRD complaint, which they might be. But what they didn't do in the article was actually show the text messages. They actually admitted in a part of this that messages have been edited for length. It would seem that if you're trying to be transparent, you would show the whole text messages, but they didn't. They edited them and they didn't show the full conversation. They took out one sentence or two sentence. What I don't see is like there's a statement at all in here from Leslie Sloane, but Leslie Sloane manages all of her PR, and PR is getting people press and it's helping them get interviews and appearances. And who's going to coordinate this with the New York Times? Leslie Sloane. So it's pretty simple here for Leslie. She coordinated and operated and created this opportunity by going to the New York Times and seeding this information to them. So for her to act like she didn't do this is ridiculous. They also discuss about the interrogatories that they say are overly broad, and they make a really interesting point here because interrogatory number 3 says identify each person you allege communicated with regarding the Wayfair parties. As set forth in the Wayfair parties' formal responses and objections, this interrogatory is not limited to matter that is relevant to any party's claims or defenses. So Sloane said that they were trying to say that she was being sued for defamation and false light based on unidentified conversations that she allegedly had with an unidentified person at an unidentified time using unidentified words. But they say that it's not limited to identifying the names of witnesses with knowledge of information relative to the subject matter of the action as required by this, and that it exceeds the scope of Local Civil Rule 33.3. They also discuss how she did the narrowing of it to seek to identify the people with whom they communicated. And what I think is interesting is she wants to compel Justin Baldoni, but Justin Baldoni, the person, is not Wayfair, right? And so if she's asking the Wayfair parties for information about identifying people, it would be weird to ask Justin then, right? Like you can ask the company, but maybe not Justin. And they do make this point here is that the Wayfair parties responded to a different interrogatory seeking broader information. Interrogatory number 1 requests the identification of any person believed or known by you to have any information or knowledge concerning any event, fact, matter, act, allegation, or issue included in or raised by the complaint or amended complaint. And they incorporated by reference their initial disclosures, which she admits they disclosed over 150 individuals and entities that had information about what Sloane, Blake, and Ryan had done. 150 people. That's a lot of people that know what happened or have information. They also say that they didn't waive their local civil rule objection to interrogatory number 3. And they claim she used a bunk legal case for her argument as to why it should be compelled. Their argument is that under Local Civil Rule 33.3a, she's outside the bounds of what she can do in discovery for interrogatories, and they have a right to object under that. And it too broadly seeks the identification of anyone with whom the Sloane parties communicated regarding the Wayfair parties. And then as far as 4, 5, and 6, they say it's improper because each alleged defamatory statement, each malicious story portraying Baldoni as a sexual predator, each of the stories critical of Baldoni, these are impermissible contention interrogatories that exceed the scope. They say in their plea for leave to exceed Local Rule 33.a, the Sloane parties disingenuously contend that they need a basic roadmap of the claims against them to prepare for their defense. However, as detailed above, the amended complaint specifies the media outlets with whom she conversed, approximately when she spoke to them, and the words she used during those conversations, to the extent the Wayfair party's specific knowledge of facts relating to her defamatory statements. If she has engaged in other defamatory conduct, she will not need to guess which of those are defamatory because she's the one who made the statements. And as for her need for the news articles that they allege are defamatory or otherwise actionable, she will obtain them in document discovery. Did I not say yesterday that she knows who she spoke to and she knows what she said and to whom and to when? And she has all of the emails and texts on her own end. She has all of the discovery herself, right? And that's what I said yesterday. And they said the exact same thing. She knows who she spoke to, but we will give her this information when we produce these documents. But if there's stuff that we don't know about, she knows what she said and to who. It's ridiculous, quite honestly. And with regards to her wanting all of the evidence that comes forth with the amended complaint that they haven't filed, they said the second amended complaint that does not exist, may never exist, and of course has not been filed. The Wayfair parties objected on the grounds that the request seeks information protected from disclosure by the attorney-client privilege, work product doctrine, and any other applicable privilege. They further objected to the request as premature. Like I said, it was premature because a second amended complaint does not exist. The case cited by the Sloane parties stand for the unremarkable proposition that a party must produce documents referenced in its pleading. If a second amended complaint is filed, they will produce all non-privileged documents relevant to the claims located upon a diligent search to the extent that such documents have not theretofore been produced, including any document referenced in such currently non-existent pleadings. I really like how they're pointing out that she's asking for something that they haven't filed. And they're really driving home the fact that she's asking for something that they have not filed. And the last part of this is exactly what I said yesterday. We respectfully request that the court deny the Sloane's party's motion to compel. Unfortunately, the Sloane party's true purpose in filing the motion is not to compel discovery, but rather to re-argue their sub judice motion to dismiss, which they anticipate will be denied based upon the court's denial of their motion to stay discovery pending their dismissal motion. Did I not say that? They were trying to get the judge to remember that they filed for a motion to dismiss because they have a feeling that it's not going to be dismissed. And if you were going to compel someone and you believe you're going to be dismissed, why are you trying to get documents? The only reason you would be filing a motion to compel is if you knew that you were not going to get your motion granted. Here is some information for those of you that are wondering, what are the rules for judges ruling on motions to dismiss? The current timeline for this litigation is they are supposed to go to trial in March. The likelihood that this will go to trial in March is slim to none. Cases rarely ever go to trial at the original date that is given for a trial. In federal court, they are often extended years. It can take years to get through the federal court system, and it can take years to get through any state court system with a civil case. So to be annoyed after 4 months is very premature because this case could drag on for 3 or 4 years. That's the truth. And it might make some of you frustrated, but that's the truth if they don't settle. And so what do judges have? What's their timeline? Well, according to the federal rules, a judge has to either make a ruling within 6 months on a motion to dismiss or set a hearing on something that has not yet been decided within 6 months. Sometimes with motions to dismiss, they will do a hearing so that the sides can argue. In this case, it does not appear that she's going to do, or they are going to have a hearing where each side can give their best argument to the judge. So if that's the case, he will rule within 180 days. Leslie finished hers and it was fully briefed, I believe, mid-March. So she's a month and a half in. She could be waiting 4.5 more months. And a lot of federal judges do not make rulings until they absolutely have to because judges are busy and unfortunately in the world of the Southern District of New York, they have way bigger cases to deal with than this, right? There are criminal cases that these judges are sitting on and are dealing with actual real issues that are impacting people that are victims of crimes, not civil cases. And the cases that are the most emergent are the ones that end up getting fast tracked. And criminal cases, because they have a speedy trial guideline in federal court, tend to go faster than civil cases and have precedence over civil cases. So, with that said, Judge Lehman is probably presiding over many cases right now, many that are far more important than this, that have cases that he needs to be ruling on, right? So he's probably got motions to dismiss from other cases that he hasn't even seen yet. So for her to suggest that it like needs to happen now is ridiculous. And I would guess a motion to dismiss like will not be ruled on until the last possible moment, because they will use the amount of time they are given often and not a day sooner. That has 100% been my experience in both federal court and state court. Okay, so what I like here is that they're pointing out the things that I said, and I don't know if they watched me. Maybe I actually got something right here, but that she knows what she said. It's extremely premature. She's asking for things from something that hasn't been filed because she's panicking, obviously, and that she wanted to re-argue her motion to dismiss. So when something is sub judice, it means that it's under consideration by a judge. And so technically, they should not be using this motion to compel to re-argue their motion to dismiss, which is another reason why it's being brought up. He hasn't decided. They shouldn't be bringing it up in another filing until it's decided. And they shouldn't be re-arguing their motion to dismiss in another filing again. And if this is what I believe they're doing and they believe what they're doing, judges don't like that at all. It's an abuse of the court system and the resources. So while Blake and Ryan and her PR is all over the media trying to make you forget about what's happening, I'm going to stick to what's actually going on, and I'm not going to get lost in the lies of Blake Lively and Ryan Reynolds, the two biggest narcissists in Hollywood. And I'll just remind you that they pay people, they pay off people, and people are clearly scared of them because this is what they do. And when people do stuff like this, the press either only does positive stories or they don't, or they bury the negative because they don't want to deal with the vitriol. I watched Todd Chrisley do this during his criminal case. No one in the mainstream media was reporting on his case because Todd would threaten to sue everyone. And none of these outlets wanted to be sued by him. So they would just literally only post fluff pieces because he would threaten them. And if I were to guess, that could be happening here. So just consider the source of where you're getting your information on Blake Lively and Ryan Reynolds. All right, you guys, let me know what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.